Welcome back. Let's bring in our guest, legal practitioner, Liberal Ochoma, joins us on the program. Mr. Ochoma, thank you so much for coming on the program. It's a quick return for you on this one. Good morning. If you can help us unmute your device so we can hear you.
Yeah, I can hear you now.
Yes, so we had to call on you because what is going on has to be interpreted by legal minds. So we told the politicians to hold on, let the lawyers explain to us what exactly is playing out. So I have my questions will stay more on the legalese here. So the underlying issue here is about the logo of a group or an association called the PMP as against the NDC, which is a registered political party by a court order that ordered the court ordered INEC to register it in December 2025. Now, the issue in question is that a court that gave that particular order in Locus sat on it again to say, we didn't get all the material, let me use a layman's term, all the things that we're supposed to get as far as this issue is concerned, especially it has to do with identity conflict. So based on the new information we have, please, you see that position we took, we're setting it aside. Let's start again. Help us understand what is going on here. Who has Locus? Can the court sit on his own judgment? Help us make sense of the situation.
Yeah, thank you for having me once again on almost similar issues that we had discussed before now. Remember the last time I was in the studio. Unfortunately, I'm not able to come to the studio today because I have my leg hot. Let's backtrack a little and look at this issue, looking at the logo, for example. The court, because we all agree, it's a preliminary, it's a notorious fact that once the court delivers a judgment, the court becomes factus officius, except it can be shown that that judgment was, there was non-service on the other party and that judgment was obtained by fraud or that material evidence was suppressed. But in this case, the question you would ask, looking at the fact of the case, was material evidence suppressed? So let's look at what actually happened. When the judge first considered the originating summons, and if you look at the affidavit, the counter affidavit of INEC in that matter, even in the judgment, this present judgment, the court did say that INEC deposed to the counter affidavit that the reason for not registering the NDC was a conflict in logo. So the issue of logo was a material fact that was argued in that application. But the court in its wisdom went ahead and requested INEC to go ahead to register the NDC. So the logo issue is not a fact that was suppressed, and it is not a fact that just came to the fore. And then secondly, when was this judgment delivered? The judgment was delivered on the 10th of December 2025. And when was this application to set aside filed? The application to set aside was filed on the 5th of May 2026. That's almost 5 days short of clear 5 months. And if you look at, I think the case of Hope and Hope Rising, Supreme Court had decided succinctly that in looking at the application for a review or to set aside, you also look at the attitude of the applicant. Was it timely? Did the applicant act in a manner that the court will agree with them that they did not see this judgment early and that so they are coming 5 months after? Is 5 months after reasonable enough to say that, yes, the court can now sit back and review the judgment that they delivered 5 months ago? Also, will the other party be prejudiced? I take our mind back to the issue of the Supreme Court judgment in Umaru and INEC. In 2007, the Supreme Court agreed that there were irregularities in our election. Justice Nikitobi of blessed memory, in his wisdom agreed, even though the minority judgment of Justice Ogutade disagreed. But the majority judgment read by Justice Nikitobi said that there were irregularities in our election, in that election. But for public policy's sake, for public policy's sake, and public policy can be all encompassing. The fact that the money that have been spent in that process, the money that will be spent also in doing the election. And that's so for that reason, those irregularities were not substantial enough, and so they allowed the election. In this case, you ask the question, will the other party be prejudiced? Based on the court judgment that the court had delivered, that party had gone ahead to collect money from people, and they had also gone ahead to register people. They had registered members, some members who have had to travel and incur costs. All of this, the court didn't put it into consideration to say, well, we consider the issue of logo in the first place, and then also your application is coming very late, too late in the day. And then lastly, we put into consideration the issue of public policy. People that had shifted their position acted on the order that the court made. At this rate, we can no longer reverse what we have done. And so we will ask you to go to the Court of Appeal if there is time for you, because already they know that the time for appealing that judgment also had lapsed. And on this note, please permit me to quickly, I want to read the dictum of Agbola JSC in Nuhu and Ogele, in Oyebuchi and INEC. And he said, a decision by a court on an issue which that court cannot revisit, reopen or reconsider is a final decision on that issue. It matters not that the decision is made at the interlocutory stage or at the conclusion of the proceeding, or that it does not finally determine the merit of the case or the right and interest of the parties. So in this case, the court had taken a decision. Whether it finally determines the right or interest of the party at this stage, it's immaterial, provided at the initial stage, when that originating summons was filed, the court had ample opportunity to look at the issue of logo, which they did before they granted that order, judgment against INEC to register NDC. The court makes so much weather out of paragraph 14 and 15 of INEC counter affidavit, saying yes, the two logos are similar. That was the same reason that INEC gave in their previous counter affidavit why they did not register NDC ab initio.
So, Mr. Shoma, if I hear you correctly, you have said a number of things. In fact, you have provided us insight into the reason, the basis for the earlier ruling of the Kogi State High Court, that in fact there was full disclosure and the matter of logo was considered. You have also asked why this peace movement party waited a whole 5 months after before, raising this application for a review of the court order, amongst other things that you have said that have given us clarity. But I also want you to now speak to the position expressed by the founder of the party on our sister political program yesterday, wherein he challenged the jurisdiction of this court to consider a matter that it had initially reviewed, initially considered prior to this time, saying that it's not a court of appeal and it has no powers to review it. From your own legal standpoint, is that also valid?
Yes, that's why I told you, I cited the dictum of Ayola GSC just now in Oyebuchi and INEC. And also, there are ingredients that the court must consider in reviewing its own judgment to set aside that judgment. In this case, was there patent defect? Even if there are patent defect that the judge would consider, the question is, does he have the power to consider those defects at this stage? He does not have the power, because except he wants to correct clerical errors. Certainly, where the process is served, the processes were served, and was the issue of logo considered, the new novel issue or the material fact? The material fact was considered at that time. Also, assuming without conceding that all of this did not happen, did the applicant also act timely to bring this application before the court? Certainly, the applicant did not act timely. And in one liner, the judge said that the applicant deposed to affidavit that he became aware of the judgment in April and he believed. Tell me in this country if there is anybody, not talk of a politician, who is not aware that a judgment was delivered in December, ordering INEC to register NDC. Also, who is not aware that since that November, NDC had been registering members? Who also is not aware that, the leader of the NDC also announced on the floor of the House that was shown across board, across all television, on the floor of the Senate, that he is now a leader, a national leader of a party? Who is also not aware that this matter was debated across various television and international platforms on registration of the NDC? Who is also not aware that there were so many comments as regards, the court will also deregister the same NDC. All of these are notorious facts that were in the public. So they say in law, equity aids the vigilant and not the indolent. So a court now aiding indolence. You said you were not aware of a judgment that was delivered in November, and you became aware in April. As at April, when you became aware, you also did not file your application. You filed the application in May. The application is dated May 4th and filed on the May 5th. So the court now closed its eyes to all of these things and in one-liner said you believe that the man had given enough reason. That alone should have warranted the court saying, you know what, I can't help you at this stage, go to Court of Appeal. So I think in that wisdom, that's those that said that the court was robbed of jurisdiction to revisit the case, in my opinion, spot on to have said that. Because if you look at all the parameters and all the ingredients to be considered by the court to grant an application to set aside his own judgment, all of these ingredients, none of them is present in this case. And the issue of the logo that they are trying to highlight, if you go back to the previous judgment and this current judgment, you find out that INEC had consistently maintained that the reason for not registering NDC was a conflict in logo.
So, if the issue is functions official, if the premise for revisiting is not met, I'm talking about nullity, I'm talking about whether it's a deceit or default, if it is not timeous, what exactly is the premise of revisit and decision that has upset the polity now?
Unfortunately, this is the problem that some of our courts, with all due respect, are creating for all of us now. And that's why I feel so sad when people look at me and say, Liberals, your institution, you people are the problem of our democracy. And sadly, it is because of judgments such as this. When even the common man, who is not a lawyer, will listen to analysis and look at the parameters for revisiting a judgment, and you say they are not present in the instant case, vis-a-vis the fact of the case, and yet a judge goes ahead to, determine the matter that way. So you you ask yourself, what would be the motive for doing this? And I said just now that if assuming without considering that all of the issues, including logos, were not discussed, but for public policy's sake, the fact that your order had made a lot of people alter their position, for all you know, because we don't have record here, there are people who would have even died in the process of traveling from point A to point B to register for this political party that your order instructed INEC to register. All of this, the court did not take cognizance of this notorious fact that people have altered their position also. This is not a question of morality, because some people will say, oh, you're preaching morality. No, this is a question of law. Public policy is a question of law that the court also do not close its eyes to, because the judge lives in our society, in the same society with us. And then also the fact that on the basis of this, the party had altered its position, collected money from people, and then now you also need to consider the time for doing this. if you ask yourself, if you are not asking all of the parties to come before you, assuming without conceding that this same political party is registered or the matter is considered, sorry, at the end of the day, you now ask all of the parties to come before you, and then you, in one liner again, or just one day, because it's originating application, you consider all of the prayers, and then you grant the order again, go and register. And then 5 months later, just few weeks to the election, another party comes and says, you see, I submitted my application. The name of the party has the NDC. My own is so similar to it that I should have been considered. Are you going to grant another application again to say, let me set aside, and so that you will come before me? If you do that, what you are having is there will be no end to litigation. Then the provisions of the Constitution would have been serially violated. That also makes provision for the hierarchy of courts. So that means a court can perpetually sit on appeal over its matter, provided you find a loophole for bringing an application to set it aside. The Supreme Court in Pretoria authority have laid down the provision, the criteria you can under which you can set aside a judgment. A court can set aside his own judgment. And like that was why I had to marry those issues with the fact of this case. And they do not tally. They seriously do not tally.
Just to be sure, you said a court can't set aside its own judgment. That's exactly what you said.
Ordinarily, the court cannot set aside its own judgment,
right.
except there are exceptions to that rule. To every rule, there are exceptions. Except that judgment was given without jurisdiction. The judgment also was given without service, because service also confers jurisdiction on the party. The judgment also was given by fraud. The judgment, there were material facts suppressed in obtaining the judgment. And also, the judgment, if it's a consent judgment, the court later discovered that the party didn't actually agree. But in considering this exception, the court also needs to look at what was the attitude of the applicant. Was the applicant timely? Was it, did the applicant behave in a way to draw the sympathy of the court to say, yes, you know, we sympathize with your cause? Also, will the respondent be prejudiced if that application is granted? All of these are the criteria that the court must look at in granting application to set aside. So in this case, that was why I had to bring the fact of the case. What is the new evidence that the court used to set aside this? The new evidence is that logo. That new evidence was considered in the original application. INEC deposed to a fact that because of the conflict in logo, we did not register this NDC. The court considered that fact in delivering a judgment, an earlier judgment. So now, reconsidering the fact, that was why I brought the case of Onyebuchi and INEC, that the court can no longer, at this stage, reconsider that fact again. It is now left for the Court of Appeal.
All right. Another clarification that we require at this point in time, because I'm not privy to what was filed by Mohammed Sani and others, in which the Kogi State High Court initially mandated INEC to register NDC. This Peace Movement Party, is it a new actor in this particular case, or was it the same actor in that old suit between Mohammed Sani, others, and INEC, in which the Kogi State High Court now asked INEC to register the NDC? Is it a new actor on the scene, or it was always listed in the old case?
I didn't get your question. Whether
this peace movement party that has brought
the Peace Movement Party was not part of the original case. And so if you read the judgment, it is stated there that is an applicant. Is the applicant asking the court to set aside the judgment that it made, that he just became aware of this judgment. So,
Mr. Shoma, based on this, does Peace Movement Party, coming 5 months after that old order had been given in December 2025, does it have locus in this matter?
That's why I'm saying that even though the issue of locus, it's not a straight jacket thing. It is a fact that will determine locus. The issue of locus, peace movement, first and foremost, if truly, indeed, in fact and in law, that the decision of the court affects them and they also, were not aware of this matter and that the decision affects them negatively, they have a locus to apply to the court to set aside. But the court in granting that prayer, the court in granting the prayer will have to look at the attitude and also the fact that they have presented in this matter. So, the fact that they have presented in the matter is the fact that their logo is similar to the logo of NDC and that they submitted theirs in 2015, NDC submitted theirs in 2017. And so to that extent, that granting this registration, their registration also, they are fighting for registration. Even if at the end of the day that the registration is granted, that means it will conflict with the logo. So the court now decided, okay, well, since these people have shown cause that their logo, and INEC has said the logos are similar, and so, yes, they have a locus. But the question I am saying, the issue I'm saying is that even without them being in the originating case, INEC has stated in that matter that the issue of logo was considered before the application not to register NDC. That issue was already considered. The position of the political party, the applicant now, had been considered by INEC. And they had stated that material fact before the court determined. So if you now come before the court in arguing your locus, what the court ought to have done would be, well, this your position. INEC had placed that position before me in considering my original judgment. And I don't see it as a new information coming to the fore that if that information was before me, my judgment would have been otherwise. INEC placed it before me. My judgment is the same. The only person that can review this judgment now is the Court of Appeal and not me. So that will now determine the question of locus and the question of jurisdiction or jurisdiction to reverse the earlier judgment delivered. In this case, the court in one line has said, well, you came, I agree that you became aware of this judgment late. And also I agree that the issue of logo was not properly considered in the previous judgment. And so now, let everybody come and state before me. What are they coming to state before you again now? When in preliminary, you have agreed that the two logos are similar. You have agreed preliminary that these two logos are similar. And so you have set aside your order. So you're not asking them to come back. Come back to do what before you? To tell you again that the two logos are similar, and you now say, well, I will no longer register this, I rescind my decision. INEC, you can no longer register the NDC. No, you can't do that.
All right, Mr. Shoma, political litigations and jurisprudence is very concerning in Nigeria, and that's why we have people like you. So, simplistic, non-legal mind. The simple question. So let's go back. What logo was INEC making a counter affidavit over? Whose party's logo was NDC logo conflicting with? Because if a PMP just came, that means it looks like it wasn't PMP. Whose party's logo was that?
No, PMP's application has always been with INEC since 2015.
Okay.
NDC's application was with INEC since 2017. So when INEC refused NDC's registration on the ground that it conflicts with other parties' logo, it can be PMP, it can be APC, it can be any political party's logo. INEC just deposed to that fact. The court did not, the court in granting the application to register did not say, well, please supply me for that material to determine which of the particular logo. I am also not aware if INEC also in its counter affidavit also attach exhibits of this logo. But what I am saying is that the issue of logo was the reason INEC took that administrative decision. And so having considered the issue of logo, whether specific, particular political party, INEC has stated that we did not register this party because it conflicts with logo.
All right.
So now that the new party is coming up to say the logo of the party registered, 5 months after the registration of that party, 5 months after the registration of that party. So we are coming back now to say we just became aware that this logo conflicts with our logo.
All right, Mr. Shoma, yes, my apology. We're totally out of time. I think you made those points very strongly. So another simplistic question, as at the time, and because this looks like it's a bit disturbing. I use that word cautiously. As simple as logo is, couldn't INEC have insisted that at least just change your logo? We're talking about logo. There's nothing too special about it. It's just logo. All this argument is logo.
I didn't want to go there. I didn't want to go there because if I go there, somebody would say, maybe I'm not discussing law. I'm discussing facts. The easiest thing to do, even Corporate Affairs Commission, if your name is so similar to another name, or for example, you are registering your promate, you are registering your brand, and it is similar to another brand logo, they will tell you that your logo is similar to another logo. Change the logo. If you insist on this logo, then we can't register it. One would have expected that commonsensically, INEC would say, this logo is similar to this logo. Can you change another logo? Or that the court had ordered us to register a party whose logo is similar to yours. So that means that because even though your application came in 2015, the fact that yours had not been registered and this had been registered, that means in law, this registration now is first in time. So there is need for you to change your logo so as not to conflict because the registration is first in time. There's notice to the whole world now of this new party with this logo. So that means since your own has not been registered and this material facts were placed before the court before the registration, then certainly you will have to alter your own. It's solved the problem. But because politics here, that's why people are blaming the ruling party. Because here, people will always, want to throw spanners in the work and make a mountain out of a non-existent molehill. And I must say this, all of these are happening because we no longer grow political parties. We have turned political parties to a Chanja market, cash and carry commodity that like vehicles, Tokumbo, you buy and drive to the next spot. If you can no longer use it, you discard it. Imagine if these political parties were grown organically, and the hell that would have been let loose by now. But because we no longer want to grow political parties, we can change from one platform to another. That is why even some persons who only will be sympathetic to the cause, considering the interview of the leader of the party, who said, well, if you cannot accommodate what we have said, then go and form your own party, then those people will look at, well, good riddance to bad rubbing. But it's still not right in law. These are very simple issues that shouldn't even taking us to this place.
It's interesting, the common denominator is just logo, as basic as it is. Interesting. Mr. Shoma, we thank you.
Sorry, quickly, it is beyond the logo. It has not been taken beyond the logo because some people want to make a mountain out of it.
Yeah.
Logo.
Okay. All right. Thank you so much, as always, for bringing your expertise. We appreciate it. Liberal Shoma is a legal practitioner. He's our professor online. He teaches us law online. We'll be in class today.
yes, thank you.
We'll take a break, and when we come back, we get to the big issue of state police. Now it's going to be before, I think after the harmonization, it's going to be before the State Houses of Assembly to consider and approve for the president to assent to that bill for us to now have state police. But that's a conversation next. Stay with us.